May it please the court, my name is Bert. My co-counsel is Brian Xia, and we represent the petitioners Monica and Maria Elena Quispe. Your Excellency, my submission today will concern the issues relating to the Naira Special Military Base, or SMB, which is found on pages 5 and 6 on the Summary of Facts. I will argue the following two issues. Number one, that Naira is in breach of its American Convention of Human Rights, or ACHR, obligations to the petitioners under Articles 5, 6, 7, 8, and 25 of the ACHR. And number two, that Naira's declaration of a state of emergency in 1990 does not excuse its failure to prosecute the accused soldiers. My co-counsel will focus on the violations resulting from the domestic abuse suffered by Maria Quispe in 2014. Your Excellency, this is a case about the Quispe sisters, two young women from the indigenous community of Womi, Naira, who were detained by the SMB in control of their province when they were only 12 and 15 years old. During the month-long detention, they were accused of involvement with terrorist activities, but they were never brought before any judicial authority. During that month, their basic and essential human rights were brutally violated by the same soldiers who detained them, and they repeatedly used them as domestic labor and as targets for their sexual depravity. And yet, even after the state of emergency has been resolved, the state of Naira has allowed these men to enjoy impunity for their actions.
We're not saying that the state of emergency allowed them to do what they did.
No, Your Excellency, we're not saying that. Our submission is that despite the state of emergency, which allows the state of Naira to neglect to protect, I suppose, certain derogable human rights, the petitioner's submission is that even considering the state of emergency, these were violations of the ACHR. Considering Naira's obligations under the ACHR and under the Convention of Bellum do Para, the petitioners submit that the court should order an official investigation and subsequent prosecution of the SMB soldiers based on the Quispe's complaint from 1992. Moving to our first submission, the thesis...
How long since 1992 now?
Your Excellency, I believe it's been 26 years.
Yes, so do we serve jurisdiction?
Yes, Your Excellency, we do.
How do we know it?
Well, Your Excellency, this court, as you know, does not actually have its own limitation period regarding any crimes that have been committed by any of the member states.
Yes, well, my understanding is that in some jurisdictions, such as Singapore, there is no statute of limitation on crimes, but in other jurisdictions, such as in the US and certain states, there is a limitation on criminal acts, a limitation period beyond which you can't bring any claim. And my question is, what does this court do?
Well, Your Excellency, with regards to the domestic limitation period, we concede on the petitioner's side that the domestic limitation period in Naira is 15 years. So the domestic limitation period for prosecuting these crimes have already lapsed. However, as seen from this court's judgments in the cases of Gulacio in Argentina and Alban Cornejo in Ecuador, in cases of severe violations of non-derogable rights, this court will still prosecute the accused persons for violations. Oh, I apologize, Your Excellency. This court will still order the domestic prosecution of these violations of ACHR rights, regardless of the lapse of domestic limitation period. This stems, of course, from Article 1.1, read with Articles 8 and 25 of the ACHR, which guarantee all persons within the jurisdiction full...
Right, but I'm just trying to understand how will this court's judgment be enforced in that situation?
Well, Your Excellency, as we've seen in the cases of Gulacio and Alban Cornejo, this court's judgment will be enforced by ordering the domestic courts to prosecute these accused individuals regardless...
Which they can't do.
Well, this court has done that, Your Excellency. And our submission is this court should order the same in this case.
So in the Argentina case,
yes,
the Argentinian domestic courts also had a domestic statute of limitations.
Yes, Your Excellency.
Limitation kicked in.
Yes.
And this court ordered those courts to hear the matter.
Yes, Your Excellency, and Argentina did comply.
Okay.
So moving to our first submission, the thesis of our first substantive point is as follows. In A, forcing the Quispes to cook, clean, and do laundry in the Womi Special Military Base during their detention B. Repeatedly raping and gang raping the key space. And C. Detaining the key space on mere suspicions of being involved in the Freedom Brigade's criminal activities, the SMB soldiers cruelly and deliberately violated the key space ACHR rights. Your Excellency, at the material time, we want to highlight that there are 3 categories of violations, and I will be taking each category in turn. In Category A, forcing the key space to cook, clean, and do laundry in the Wami Special Military Base is a clear breach of their rights to freedom from slavery.
That's surely not the most important breach. Let's go to the most important breach.
Yes, Your Excellency. We would submit that the most important breach would be Category B, which is the repeated rape and gang rape of the key space, which we would submit is a violation of their rights to freedom from torture under Article 5.2. Under Article 27.2, this right is also non-derogable.
Why is it torture? Why isn't there some right for their sexual health or something like that? Rape is a crime, right?
Yes, Your Excellency, rape is a crime.
So rape itself is a sexual crime. No one says it's torture.
Well, Your Excellency, sorry, could I have a moment to...
Yes.
Thank you. Per this court's jurisprudence, the distinction between torture and near humiliating treatment under Article 5 is
you mean there's nothing in the convention that outlaws rape?
No, Your Excellency, it tends to fall under Article 5.
As torture?
Yes. The Bellum do Para does criminalize acts of violence against women, which this would also constitute a violation of.
I see. Okay. Right, so tell me how it's torture?
Well, per this court's jurisprudence, the distinction between torture and near inhuman or humiliating treatment is that torture requires A, a higher intensity, and B, a purpose. This was set out by this court in Caesar and Trinidad and Tobago, which makes clear that this court adopts this same distinction that was set out by the ICTY.
What is purpose and how is purpose different from intention?
Well, Your Excellency, purpose is actually a rather, per this court's jurisprudence, purpose is essentially a purposive element to ill treatment.
That's circular.
Yes, Your Excellency, I concede it is. But the possible elements that have been laid out by this court in Buenos Aires is for the purposes of criminal investigation, as a means of intimidation, as personal punishment, as a penalty, or for any other purpose. So the definition
what's the
itself
general principle?
Well, Your Excellency, I believe the general principle is with regards to cases such as the Key Space case where they've been detained and there have been accusations levied against them, it would clearly fall under at least one of these limbs of purpose.
And which one do you say it falls under?
I would say it would fall under either punishment or investigation.
And not intimidation?
Well, possibly intimidation as well. But as we've seen in, I believe it's clarification number 28 of the clarifications portion of the question, the Key Space were detained on accusations of aiding the Freedom Brigade, which was a terrorist organization that the state was in conflict with. And
yes, but that explains their detention. Surely when you're talking about the rape, there must be a purpose to the rape. Does the purpose not attach to the rape as the violative act instead of the detention, which I seem to think is the background?
Well, Your Excellency, I believe the background should be taken into consideration in assessing what the purpose of the rapist might have been. And this court has generally concluded that in cases of detention and then raping of the detainee, the purpose of this rape would generally be for obtaining information or for punishment for not providing the information requested.
Okay.
Yeah. In the alternative, Your Excellencies, even if you are not with us on the issue that this sexual abuse...
I didn't say I wasn't with you. Just continue with wherever you were. I think you haven't really established... What's the other element besides purpose? You said there was one other?
It's an intentional act and it has to be of an aggravated intensity.
Okay, how do I know those are satisfied?
Well, we would submit that rape meets this threshold of severity per se because the act of rape itself necessarily implies severe pain and suffering. The Inter-American Commission has noted as such in the case of Raquel Martin and Malaysia and Peru, where the Commission found rape to be a form of psychological and physical torture. Also, as
But in your case, you don't just need. I mean, there's repeated rape, correct?
yes.
So you would satisfy that criteria in any event.
Well, we would submit that it's not just the repetition of the act itself, but it's also other factors that are subjective to the key space, which include, for example, their age, for example, the fact that they were already under detention. And also, I believe the court in Rosendo Cantu took into consideration that in gang rape cases, there's a high element of humiliation that the victim endures because the act itself is being witnessed by so many people. And there's also this constant fear that these other witnesses may take part in the same rape later on.
Okay.
As such, we would submit that this case clearly meets the intensity necessary for it to constitute torture under Article 5.
Right. Were they not members also of an indigenous community?
Yes, they were, Your Excellency.
So is there something to be made out of that?
Well, Your Excellency, there was a case where involving the rape of an indigenous woman as well, but the court did not expressly take into account the fact that she was indigenous. So we would not make the argument here just to be conservative.
Why not make the argument?
Make
the argument.
Well, Your Excellency, we believe that their indigenous nature should be taken into account as well. Considering that this court in Loaiza Tamayo set out that both factors exogenous and endogenous to the victim, which simply means factors external to the victim, which are factors concerning the attack, and factors internal to the victim, which refers to factors such as age or health, should be taken into consideration in assessing the intensity of the attack. So with that in mind, we would argue that the indigenous nature of the indigenous character of the key space should also be taken into account, as indigenous people tend to be less educated, they tend to be more vulnerable.
So, yes. Okay. Yes.
And therefore would be less likely to be able to recover from such a severe violation of their rights.
Okay.
Moving to Category C, Your Excellency, the petitioners submit that the detention of the key space, without allowing them the opportunity to appear before competent judicial authority, is a violation of a litany of rights. Per our memo, it's a violation of Article 7.3, 7.5, 8.1, 8.2, and 25.1, which we have already set out. But for the purposes of today's proceedings, I will be focusing on the contentious allegations, which is that the detention of the key space for March 1992, without first bringing them before a judicial authority, is a violation of the right to trial within reasonable time. This is Article 7.5 and Article 8.1. Per the Inter-American Commission in the case of Jorge Jimenez, both Articles 7.5 and 8.1 protect the same liberties, but differ as to their reference to what constitutes a reasonable period. This distinction stems from the fact that Article 7.5 applies specifically to accused persons who are held in custody prior to the trial, which already is an infringement of these detainees' right to personal liberty and security of person. The Article 7.5 threshold for reasonability is therefore at a higher standard on the grounds that states should accordingly give procedural priority to any such persons held in custody. As such, any violation of 7.5 should necessarily be a violation of 8.1 as well.
But 7.5 and 8.1, these are rights that I would say are not derogable rights in a state of emergency. Is that right?
Yes, Your Excellency.
All right. So how does that feature into the analysis?
Well, Your Excellency, our contention with regards to these rights is that the declaration of the state of emergency does not excuse this violation as well, on the grounds that under Article 27, the state of emergency only allows the state to derogate to the extent strictly necessary, considering the exigencies of the situation.
And why is it not strictly necessary in these exigencies?
Well, while we acknowledge that this detention may be necessary in certain cases concerning terrorist suspects, the state's rights to regulate such, the minimum requirement for the European Court of Human Rights case of Fox, Campbell and Hartley in the UK is that the state must furnish at least some facts or information capable of satisfying the court that the arrested person was reasonably suspected on having committed an offence.
Do we know how long they were detained for?
They were detained for 1 month, Your Excellency.
1 month?
Yes.
why is 1 month too long?
Well, Your Excellency, we would submit that regardless of the length of detention, Naira should minimally be required to give this court some evidence that may constitute a basis for the case-based detention, something that they, up to today, have entirely failed to do.
No, I think my question is more like, surely in the state of emergency jurisprudence, 1 month doesn't sound that egregious, you know? And they were released after.
Well, Your Excellency, we have two responses to that. The first one is they should not have been detained at all because...
No. These particular rights activate when they're detained. So detention is an assumed state. You must have that. So your second response?
My second response is, even if there were some grounds for the detention, clearly 1 month is too long compared to the complexity of their case.
Why clearly?
Well, Your Excellency, they were two young girls. They were 12 and 15. There's no evidence of any link between them.
But does the right change depending on your age? Or your sex?
Well, no, Your Excellency, but there must be some justification on the part of the state for the detention, and there must be
My understanding of 7.5 is that it's satisfied as long as you bring them before a judge within a reasonable amount of time. And reasonable depends on the situation. So, in this state of emergency, why is it not reasonable? 1 month? Are there cases that say that 1 month is too long, 3 weeks is right, 2 weeks is best, appropriate, not best?
Your Excellency, regarding your concern that the reasonable lapse of time depends on the situation at hand, I believe this court in Brannigan and McBride the European Court of Human Rights in Brannigan and McBride has set out that the understanding of reasonability does depend on factors such as the complexity of the case, for example, the possibility that these people would reoffend or abscond from jurisdiction if they were not detained prior to their trial. And in this case, Your Excellency, there is no evidence of such behaviour on the case-based part. There's no evidence that their case was particularly complex. There's no evidence that, considering the court's resources, procedurally...
But I wonder now if we're confusing 8.1 and 7.5. Because 7.5 sounds to me like those provisions in other conventions which say, or in other domestic legislation which say, bring the guy before the judge within 48 hours, or 36 hours, something like that. And 8.1 is the one which talks about detention until trial. So, in this case, I'm just looking for a time period which you say they should have complied with. What time period do you say they should have complied with? That is consistent with international best practice. That this court can take account of, yes.
With regards to the time period that should have been complied with, the petitioner's submission is that the time period should have, regardless of what it should have at least been less than 1 month, considering there was no evidence at all of these allegations. It was very much, to us, it was very much an open and shut case that there was no concrete evidence to ground these allegations in, and therefore the case base was simply innocent. Once it was clear to the state...
They were detained because they were terrorists?
On accusations that they were terrorists.
Oh, okay. Okay, go on.
Moving on to our last substantive point, Your Excellency, the petitioners submit that regardless of the lapse of Naira's domestic limitation period, Naira is obliged to investigate and prosecute the accused soldiers regardless.
Oh, I thought you were going to talk about the other rights under... you said there was 25 as well, right?
Well, Your Excellency, all the other rights in this category are based on the argument that they were not brought before a judge within a reasonable amount of time. So, for example, Article 8.2 is the right to the presumption of innocence. So the right was simply violated by the fact that they were not brought before the judge within a reasonable amount of time. Article 7.3 refers to the right to freedom from arbitrary detention, which this court has held would really depend on whether the detention was legal in the first place. So if we are able to find that the detention of 1 month was unreasonable on the facts of the case, then the detention is necessarily arbitrary as well.
What is your burden of proof?
Well, Your Excellency, our burden of proof is that these allegations are made out, I believe. Or are you inquiring into the
No, that's
standard of
that
proof?
well, I think it's the same thing, but go on. Yes.
Okay. Sorry.
Well, they're not the same thing. I'm sorry. Okay, the burden of proof lies on you to
Yes.
show.
That the allegations are the
Yes, I'm sorry.
violations.
I was wrong. What's the standard of proof?
The Inter-American Court has made no explicit statement about following a particular standard of proof, but this court in Velasquez-Rodriguez has put forward that, like all international law courts, this court has the ability to weigh the evidence freely and avoid a rigid rule regarding the amount of proof necessary to support a judgment. So similar to the civil law tradition, the judges can adjudicate according to their inner conviction, which is a strictly personal matter.
Okay. But in this case, do you say we should be closer to the common law concept of balance of probabilities, or are we closer to beyond a reasonable doubt? What do you say is the standard in this case?
Well, Your Excellency, I would say the standard is I don't believe the standard is beyond a reasonable doubt. In fact, this court has already, in Sahoyak-sama in Paraguay, asserted that it does not have to follow the common law burden of beyond a reasonable doubt. And
Yes. I think I've established that I don't have to follow anything. I'm asking you what you think I should follow.
Well, Your Excellency, I believe it should be closer to the balance of probabilities. And the reason for doing so is that the objective of the Inter-American system, of course, is not to punish these individuals who are guilty. So it's not to make a finding of guilt, but rather to protect the victims. So it's not necessary on the petitioner's part to prove which individual soldier was a rapist, but rather that there was a soldier who was a rapist, and that act can therefore be
But don't you
attributed
think
to
that
the
in this
state.
case, where the allegations of a breach of the convention are premised on rape, therefore that rape must be proven beyond a reasonable doubt? Because rape is a crime.
Yes.
So would you accept then that you have the burden of establishing that a rape occurred beyond a reasonable doubt?
Well, Your Excellency, I wouldn't use the term beyond a reasonable doubt, but we definitely do have a serious burden of proving that the rape occurred.
Okay. And have you discharged that burden?
Your Excellency, I believe we have, especially considering Article 39 of the Rules of Procedure of this court, which puts forth that any allegation that the state does not respond to is effectively considered.
I see. And they have not responded to the allegations of rape.
No, they have not. Their defense in the answer to the commission was merely regarding the fact that the claim was time-barred and there was nothing they could do about this.
Okay. Yes. You were on some other point? You were going to go somewhere?
Yes, Your Excellency. On our point that regardless of the lapse of Naira's domestic limitation period, Naira is still obliged to prosecute the soldiers. On the first tier, specifically regarding the large-scale and systemic sexual abuse of the female detainees, the petitioners contend that this depravity constitutes a crime against humanity, which cannot be subject to any statutes of limitation under customary international law. We submit that the non-applicability of domestic statutes of limitation to crimes against humanity is a rule of customary international law in light of state practice and opinio juris. This court has acknowledged the existence of this customary rule in the case of Almonacid Arellano and found that Chile's limitation period did not apply to a complaint of extrajudicial execution. Crucially, Chile had not ratified the UN Convention on the non-applicability of statutory limitations to war crimes and crimes against humanity at that time. The existence of consistent state practice and opinio juris in support of this rule is also best demonstrated by the adoption of the aforementioned convention. To date, the UN Convention has 55 signatories, including Mexico, Chile, and Cuba, evincing significant state practice. Additionally, the adoption of an international instrument drafted specifically to settle this issue of statutory limitation evinces opinio juris. Finally, considering international consensus.
Okay, let's go to the convention. So that's only 55 states out of over 100 states in the world.
Yes.
So I don't think that's nearly overwhelming. And as far as opinio juris is concerned, what what is the criteria for creating opinion areas?
Your Excellency, I believe it is a belief among states that this obligation is one of law and not one of custom.
Okay, right. And how is it that there's opinion areas just by signing up to the convention? Must they not do something more?
Well, Your Excellency, we would submit that the very adoption of this convention shows that there is an intention on the parts of these 55 states to consider this a binding obligation rather than just custom.
Yes, but only these states.
Yes, but only these states. I believe there is a...
So if you accept that last comment, that's only these states, then it's not custom.
Well, Your Excellency, we accept that it's only 55 states out of the more than 100 states in the world. I'm not sure the precise number. However, we will also submit that considering international consensus regarding criminalizing crimes against humanity, it will also be a mockery of international law if the old regime can enjoy impunity by concealing evidence of its crimes against humanity until the limitation period lapses, or simply by legislating an unreasonably short limitation period.
Yes, but in this case, no one's died, right? Has anyone died?
We're not sure, Your Excellency.
Okay. So, what are the crimes you say are so severe that they are crimes against humanity?
We would argue that the mass rape of female detainees is so severe that it would constitute a crime against humanity.
So, what about it makes it a crime against humanity? The fact that it's rape or the fact that it's mass?
Well, a combination of both, Your Excellency. Firstly, we require it to be widespread and systemic attack against the civilian population. And secondly, we require it to be of a certain severity. So per Article 7.1g of the Rome Statute, this widespread and systemic rape of the female detainees conducted by state agents would constitute a crime against humanity.
Okay, so you've listed many different things there that all together form a rule. But am I given to believe that the fact that it's committed by state agents is not part of the rule?
Well, it's part of the Rome Statute, but I would think it's part of the rule.
So what is the rule?
I believe the rule is it has to be widespread and systemic, it has to be against a civilian population, it has to be against a state agent, and then it has to be one of the...
Against a what agent?
Committed by a state agent.
Committed by a state agent.
And then it has to be one of the attacks that the Rome Statute considers significant.
Yes, and what are those?
Well, Your Excellency, I do not have that information with me at the moment, but I would argue that this case would fall under Lim G, which refers to rape, or Lim F, which refers to torture.
Okay. Yes. So the effect of that is that I'm meant to do what?
Well, the effect of that, Your Excellency, is that if this is a customary international law, if we are arguing that it is, then this is a violation of customary international law. And it is trite law, obviously, that the state cannot invoke national law to justify non-compliance with an international norm. So in light of this customary international law rule regarding the non-applicability of Naira's domestic limitation...
Yeah, but I read in the problem that Naira is a monist state, right? So its international obligations apply immediately, and they would override their national obligations, correct? Is that how monist states work?
Yes, Your Excellency.
Oh, I see. Okay. We might want to check that. Okay. So, in that case, is that really an issue if the international obligations immediately apply?
No, Your Excellency. We will argue regardless of whether they apply immediately or regardless of whether they would apply after some time, they cannot invoke the national law to excuse it. That's the conclusion of the argument.
Oh, I'm sorry. I think what I meant by monist is that the international law has the same weight, same effect as national law in a monist state. Is that correct?
I'm unsure of this at the moment, Your Excellency, and
yes.
I'll have to get back to you.
Yes, okay. So it's not a timing question, it's an effect question, okay?
In the alternative, under Naira's obligation on to investigate and prosecute violations of ACHR rights with due diligence, the severity and the scale of the totality of the violations would justify prosecution even 2.5 decades later after the act. I believe I've run out of time, Your Excellency.
Oh, I see.
This has gone quite long. I wasn't taking any time.
Okay, do you want to just try wrapping up in 1 minute?
Okay.
This last point.
So,
Whatever
continue
you're on.
Well, Your Excellency, essentially, as I referred to briefly in my answer to one of your questions earlier, the ACHR has set out that this obligation to prosecute and investigate any violations of convention rights would supersede any lapse of domestic limitation periods for violations that are sufficiently severe.
Okay, I think that's no longer an issue. Is there anything else that you would like to raise?
No, Your Excellency.
Okay, Ken, thanks.
Thank you.
Yes, thank you.
Actually, before I go, can I use the restroom?
Yes, okay.